Medallia Diok. I'm going to go over the history of Undrip, and I want to say right from the beginning that has not been an individual project of mine. It was the Grand Council's desire and design, and I'm just one of the servants that worked on the team to develop this. Joby was part of their original team when we started discussing whether we were going to go to the UN. And other people came along. But the team that was designated by the Grand Council to take this to the UN was myself, Russell Bosch, my wife, Marie Batiste, and Bernie Francis was a part of the process at different times. And Stephen Augustine and other people were involved over the 30-year period, and there's too many to name. But all of them were working in a different phase, and they're working silently. At the same time, we were negotiating the Constitution, which became my primary responsibility until we got our Aboriginal and treaty rights affirmed. And then I moved to the international area with Russell Bosch and others. John Joe Sark was very much important in our process, and other chiefs and AFN and everyone else came to our aid once they understood what we were trying to do. But this is basically part of the decolonization movement that we started in 1978 when Canada wanted to bring back the Constitution. We wanted to also bring back the treaties, and we spent most of our time doing that. In the constitutional talks that Joe B. and others will remember, we advanced the issue to the Canadian government that we wanted our human rights enshrined in the Constitution. And we met a lot of resistance from that. And one of the key issues is that in a meeting, they said, well, you're just not the right kind of people to have human rights, that other people have those human rights. And we found that objectionable, but we didn't have a real clue to how to do it because Canada had affirmed the Human Rights Declaration. Canada had affirmed the International Covenants on Human Rights in 1976. And we were in 1978 saying we'll implement those in the Constitution and implement them for Aboriginal people and Indians. And they said, no, you're the wrong kind of people. From that discussion, ELIC and the Grand Council and the Union and NIB at the time all sat down and tried to figure out what we're going to do about this, that we were having no problem enshrining our treaties. We're having a lot of problems with Aboriginal rights, but we're having more problems with human rights. And so ELIC Denny, for the Grand Council, decided that we had to take this to the UN process. That meant that we had to learn a whole different system of laws than one that we're familiar with. But ELIC had explained to us that this was like a deer trap or even a salmon trap or a fish weir, is that we needed a two-sided fight against Canada. We needed the constitutional fight, and we also needed the other side to guide Canada into the right thing, was the international fight. And so he said, we have to begin to develop this. It took us a while to develop it. But one of the key things that he kept saying over and over to us is that Micmac poverty is a result of the denial of human rights and human dignity. And we didn't quite understand exactly, at least I didn't understand exactly what he was saying until we finally worked the UN declaration through. Now, the UN system is vast, and it has so many parties. It's where the alphabet goes to die, because because you're using 6 different languages in the UN, everyone uses initials because there is no standard language that they can use. And so we were in the General Assembly, but we started out with the Human Rights Council to start to articulate that the Micmacs have a right to self-determination, and more importantly, the Micmacs had a right to be involved in the constitutional process and select our own representatives instead of the Prime Minister selecting representatives to speak for us. And that was the underlying theme behind all this. Now, the Human Rights Committee in Geneva is huge. This is just a picture of it. Every knowledge system in the world, every language in the world, every high-priced diplomat in the world is part of the UN Human Rights Council. And to work your way through that, you have to have a lot of patience because of all the diversity of thought that's there, some good, some bad, but they're all trying to do the same thing of bringing human rights into the world at that time. And we decided to go there. The vehicle technically we used is the UN International Covenant on Civil and Political Rights, which really just said what we had been saying all along, is that we have inherent dignity and we have inherent rights, and all peoples, including Micmacs, have the right to self-determination. And the federal government at that point was saying, even though it says all people, they were reading it as all people except Indians have the right of self-determination. And we were saying that's the wrong kind of interpretation of the human rights. The second part of the battle was about the right to participate in the conduct of public affairs through our own chosen representatives. The way we get to the Human Rights Council is through the UN Optional Protocol of the International Convention on Civil and Political Rights. And that's when Canada affirmed this, they gave us the right to communicate with the Human Rights Committee for violations of our rights that are set forth in the covenants, the international covenants. And those covenants were the right of self-determination and the right to freely participate by our own choice in the constitutional talks. We couldn't have used this communication if Canada hadn't acceded to this, and they had ratified it in 1976. So that was the door that we opened and went through and drafted the system to assert our rights, our human rights for the Micmac people and the Grand Council. We started this in 1980 as part of the constitutional talks. We also developed that, and we sent the communication, which this is the letter that covers the communication from Allegheny to the Human Rights Committee, asserting our communications of the violation of self-determination, a violation of our treaties, and a violation of not allowing us to participate in the constitutional talks through our own elected representatives. And this was the treaty area we claimed. While we were in the international process, we also succeeded in getting the Canada Act that recognized our Aboriginal and treaty rights. And we also worked on the Charter of Rights of Canadians to make sure that that didn't affect our Aboriginal and treaty rights. And one of the part of the things we established was a constitutional conference to clarify Aboriginal rights after 1982. At the same time, in 1981, the Maui-Omi began their advocacy on self-determination within the UN Subcommittee on Minorities. And they had an annual working group on Indigenous populations. notice the words here. There was nothing in the UN that covered indigenous peoples, because that would mean that the covenants applied to indigenous people. And even at the UN level, they were resistant to the idea that indigenous peoples were part of all peoples who had human rights. So we had to work through that. And this is very hard advocacy for 30 years. It took us 10 years to prove that we were human before the committee, that they had challenged whether indigenous people were actually humans or actually people who deserve these rights. And that was a very degrading and disgusting discussion of trying to say indigenous people are humans. That it struck us at the beginning as absurd, but then we had to prove that to the UN committee that we were before we could move on. And that's a very hard thing. We went through that process of trying to prove that we were humans, and at the same time, in the Constitutional, we had the first Ministers' Conference on Aboriginal constitutional matters that started in 1983. And once again, even though we had affirmed our Aboriginal and treaty rights, in this first Ministers' Conference, the Prime Minister refused to invite treaty nations to the Constitutional Conference, and instead invited the national organizations of Indians, Métis and Inuits, and non-status Native Council. And once again, the Grand Council said that's the wrong approach. They aren't the treaty rights holders. They aren't the Aboriginal rights holders. That the executive of the Maui decided to say that this is another violation of not only our constitutional rights, but also our rights to self-determination. We ran into a problem with Canada of saying, well, no one would recognize the Mi'kmaq Nation as a nation. You're just a minority, you're just a special interest group. And so Alec Denny said we have to resolve that problem, and we have to resolve that problem in a way that they can recognize. And so we started working on that at the Grand Council level of trying to find a partner who would recognize the Mi'kmaq Nation in the United Nations. And eventually we were recognized as a treaty nation by the Chancellor of Austria for the European Economic Union in 1983. Now, Albert Marshall was there, Alec Denny came, I was there, and we had a head of state meetings with the Chancellor of Austria, where he recognized the Mi'kmaq Nation for the Economic Union. And that, in the UN process, gave us a lot more credibility and started allowing a lot of other people to come and support what we were trying to do, especially AFN and other people. That this was our first step toward self-determination and our right to choose our political relationship. We continued this by working through the UN Working Group on Indigenous Populations from 1985 to 2001. That was Professor and Dr. Eric Diaz was the founding chairperson. And we started making comments every meeting about self-determination, about our rights to have the human rights covenants. And eventually we worked on the draft of the Universal Declaration. And myself and Russell Boyce were involved with drafting it, as Professor Diaz appointed us to the drafting team, and we continued on through that process for the whole process. When we reapproached Canada after we were recognized as a treaty nation by the European Economic Union, and we were in the process, we wrote to Canada and said we're prepared to discuss from the Sante Maoyomi position a treaty or political relationship. But the Canadian government was reluctant. They kept saying, no, we only deal with Indian Act. That's our responsibility. And the Prime Minister said the same thing to us in response to all of our attempts to be involved in the constitutional process to clarify our Aboriginal and treaty rights. With this, we then had to reconceptualize our original communication to the UN in 1986, and we had to do it to conform to what the Human Rights Committee had said, is that we originally put in the communication from Alec Denny for the benefit as G captain of the Mi'kmaq Nation and the Sante Maoyomi. And they said, well, you don't have approval from all of the nation to do this. And so we had to rejig and redevelop our communication to the Human Rights Committee, and we did that. And this was after our Aboriginal and treaty rights were affirmed. This was after the Simon decision affirmed our treaties were valid. So we got together the Grand Council and had a 2-year discussion of this. And eventually, with the help of Will Bask and Michaelo, we convinced the Grand Chief and the Badus that this was the right thing to do. They were getting a lot of pressure from the federal government to not go forward with our communications, to not go to the UN system, and to not maintain in the Sante Maoyomi's position through it all. But we overcame those obstacles, and all the executive members sent a new communications to the Human Rights Committee under the optional protocol from Grand Chief Donald Marshall and Grand Captain Alec Denny and Badus Simon Marshall as the executive. And our position was before the Human Rights Committee is that the Supreme Court had affirmed Mi'kmaq treaty rights in the Simon case, and that the treaty rights are part of the supreme law of Canada and they're evidence of our self-determination. And the Mi'kmaq are the victims of colonization and racism and related intolerance. And we deserve and should have affirmed our right to self-determination and our right to conduct constitutional affairs by our chosen representatives. The self-determination that we were talking about is not the self-determination of the Maoyomi, but it was the self-determination of each Mi'kmaq family. Each Mi'kmaq clan had the right to determine how they wanted to be situated in Canada and the relationship to Canada. And that's the argument that we were putting forward. And that's what we sent the communication to say. Canada's position was against our petition. Their position, they said the Mi'kmaq are minorities, not peoples. Once again, our humanity was turned into the special interest. They said the Mi'kmaq Indians or individuals cannot invoke self-determination, that Indians cannot have an international personality. The Mi'kmaq still, they said, had no valid treaty rights, and the Mi'kmaq haven't exhausted all of our domestic remedies, which we should have done before we went to the UN. And they said that the constitutional conferences, the First Ministers' conferences on Aboriginal matters, deals with self-government, not self-determination. And they said that Micmac participation in the constitutional conferences was not feasible and not practical. And Micmac self-determination will disrupt the national unity of Canada, which was their really strongest point. The UN Human Rights Committee in 1991 decided two things. One is that the Maui-Omi's communication was admissible under the principles of the right to conduct public affairs directly and through freely chosen representatives under Section 25A of the Covenant. That's part of what we wanted. But the second thing the committee declared that the communication was inadmissible in respect to the claims of the violation of a collective right of self-determination. Not because we didn't have a collective right of self-determination, but because the committee had not been given jurisdiction by the General Assembly over collective claims. Even though they used the word Indians and individuals in the covenant, they said this only applies to individual claims. And with that, we then turned to the committee to make a final decision, because in the UN system, you have to get jurisdiction first and then you make your case. And then we started to make our case, but unfortunately, the constitutional conferences concluded before we could make the case. So the committee decided that this was a moot point and decided not to make a decision on this. But the key thing that we took from this, that we took back to the Grand Council, was that it's clear from the communications that we need the General Assembly to say that Indigenous peoples and Micmac people in particular have the rights in the human rights covenants. That's the only remedy that was available to us. And with that, we started the process of drafting a much more deeper document on the rights of Indigenous peoples in general. We drafted that by 1995. We submitted it to the General Assembly and to the Social Economic Committee, and the states were a little bit threatened by what we had written, and they set up another working group on the Commission of Human Rights to look at our draft that we had put together in the Working Group of Indigenous Peoples. And we had another 10 years of bitter, divisive comments, section by section by different states. At one time, the only thing that survived in the whole draft was the rights of women. Every other clause had been challenged by some state. And so we had to work out in those 10 years, clause by clause with the states, why these rights applied to us. We finally submitted a revised draft that was very much similar to the original draft. And in 2006, the Human Rights Council adopted the revised states working group draft of the declaration, and then they sent it to the General Assembly for a decision. At the same time, in parallel, Marie Batiste was delegated by the Maui-Omi to work with Erica Diaz to work on the UN guidelines for the protection of the heritage of Indigenous peoples, which was a parallel process. And eventually she became the first Indigenous chairperson or rapporteur of that in 2000 at the turn of the century. And they drafted a code about how to protect the heritage of Indigenous people and especially the Micmac people. We sent this to the General Assembly, and even the night before and the weeks prior, Canada kept trying to get us to back off of the draft declaration, saying that, well, we really don't have the support in the UN General Council, and we were going to lose the vote, and don't take it to the vote. We had problems with Africa, not being happy with the human rights idea for Indigenous people in Africa, and we had to spend a lot of time with the African Human Rights Council to assure that we would get the UN declaration passed. And they wanted some recommendations and some things, but eventually we said, no, we're tired of negotiating and compromising, that this is the minimum that we can agree to. This isn't the maximum, and we're going to take it to the General Assembly for a vote. By this time, we had created a whole Indigenous diplomacy network across the world, from New Zealand to Australia to the United States to the Far East to Africa. And our human rights working groups were the largest human rights working group in the UN of about 2,000 people every summer, convening to work on the declarations with the states. So we had a broad consensus among Indigenous peoples, which was very hard to get and very hard to maintain and very hard to push forward. But we decided that we had the votes and we had our commitment to it. And so we took it to the General Assembly for a vote, and the General Assembly voted for it. And so was passed the UN Declaration on the Rights of Indigenous Peoples. Canada, of course, abstained. The United States abstained from the voting. Well, actually, they voted against it. Australia voted against it. New Zealand government voted against it as a bloc. But in general, we had 144 nations agree to this as the global minimum on human rights that apply to Indigenous peoples. In 2008, we took the UN Declaration on the Rights of Indigenous People to the Grand Council, and the Micmac acceded to the UN Declaration on the Rights of Indigenous People at that time. And Grand Chief Sillaboy signed the statement to the High Commission of the Human Rights that the Micmacs agreed to make this part of their constitutional law. So we accepted and recognized the Undrip as the responsibility of self-determination. And self-determination is the key, because on matters of implementation, self-determination is the moving force for all the other inherent rights in the Declaration. Without the right of self-determination, none of the others make sense. And we then turned to Canada and said, we want you to cooperate, and we want you to move this into federal law. And once again, we met resistance and reluctance and denial. But it didn't make much difference to the Grand Council that they had decided that this is what we're going to do. This is sort of a timeline of the process that we finally, have Canada accept Undrip in 2010 as sort of a aspirational document that works through the Constitution. But that wasn't enough. So it took us to the World Conference on Indigenous People, where we got all 193 member states of the UN to express their support. And that included Canada. All the people who had voted against the UN Declaration at the General Assembly had now agreed by 2014 that this was the global standard. And Canada went forward in 2016 and said that they fully accept and ratify the declaration before the General Assembly. And then in 2019, we got the BC Indians got the BC government to enact a statute called Undrip, or UN Declaration of the Rights of Indigenous People Act, that says that BC laws have to be in alignment with the UN Declaration. We then turned our attention to the federal government again through Romeo Saganas, a Cree who had worked with us for many years in the declaration. And we introduced a private bill, which failed in 2020 because of the conservatives, and I'll go over that a little bit more. But through the efforts of our senators and our MP, that are Micmac, we got the bill through royal assent in 2021. And I'll go over those in little details, but that's just the scope of all this. And every year was heartbreaking in a different sense and frustrating of getting Canada to where we wanted it to go. Now, the UN General Secretary statements on it said that this is the visionary step toward addressing this, and it sets out a framework for states. Now, the Maui-Omi helped Canada to incorporate Undrip into the federal law, even though Prime Minister Harper said it's an aspirational document and the NDP presented the private bill. The Conservatives were against it and the big corporations resisted, and they stalled the bill. And the thing that they were most unhappy with is the idea that Aboriginal peoples will have free, prior, and informed consent under the human rights. And they argued that this will cripple, disrupt natural resource development. And they kept using this weird word of Indigenous people will have a veto over natural resources. And we kept teasing them that we don't have an Uncle Veto. You know, we're not going to stop anything. We don't have that kind of power in Parliament, but that there was no veto in the declaration. It's just that you have to consent with us before you do something that's going to affect our human rights, much less our Aboriginal or treaty rights. But we finally convinced the Liberal government to implement Undrip into federal law, which they did. Now, the BC Declaration was the first, but it mandates that the BC government to align, and I'm trying to figure out the right Micmac word that you'll help me with later in your discussions of what does align mean in Micmac. You have to align the provincial laws with the inherent rights of Undrip. And it was a very vast one, and the federal government is the same kind of law. That the Micmacs in Parliament that guided the UN Declaration of the Right through Parliament was Senator Danny Christmas and Member of Parliament Jaime Batiste and Senator Brian Francis. And all of them exercised throughout all the parliamentary discussions the version of Alec Denny's claim that Micmacs have to represent their own people and through their inherent right to conduct public affairs in Canada. These became the actual realization of the right to conduct public affairs in Canada through a parliamentary system of Micmacs representing them. And it did what Alec and the Grand Council wanted it to do. The federal government passed the bill, as we call it, Fundrip. It's the Federal United Nations Declaration on the Rights of Indigenous Peoples Act. And it's a living achievement and commitment of the Micmac Nation in Canada and with other allies. And it's the critical porthole for recognizing, promoting, and upholding Aboriginal treaty and human rights for Micmac families, clans, and peoples for a better future. I want to go over some of the provisions of it, just to be clear of what we're saying, is that the Federal Act provides that we're going to uphold the rights of the Micmac Nation that's recognized and affirmed by Section 35 of the Constitution, and not to abrogate or derogate from them. We're looking for this word uphold in Micmac, and you'll have to help us with what word you choose. But the key thing is that the government of Canada must, in consultation and cooperation with the Micmac Nation, take all measures necessary to ensure that the laws of Canada are consistent with our Declaration of Human Rights. Now, the federal legislation or the BC legislation does not turn our inherent rights into the federal government or to British Columbia. That what it requires is that they respect and make their legislation federally and in BC consistent with the inherent rights of the Micmac Nation. And I have to stress this inherent rights. We have argued to Canada, and we argued it in the UN, that inherent rights do not need any statutory affirmation to exist and be valid, that they come with our birth, they come with our creation. And these are a manifestation of the Micmac language of our embodied life spirits, the Wijigjama, the inherent rights that are within us, that we're not talking about anything that other people look at us. This comes from us. And in the UN system, they say in the human rights, the Declaration on Human Rights, that all humans are born free and equal in dignity and rights. And they're endowed with reason and consciousness and should act toward another in a spirit of brotherhood. But that everyone has this right to life, liberty, and security of person. Those are all inherent rights that no government gives you. No power other than the Creator gives these to you, and you carry them within you. And so you don't start looking elsewhere for where these rights are. You have to look inward to your own consciousness, your own thinking. This is where the rights come from. And so when we get to making them consistent with federal laws, we're dealing with something that is not coming from government, but that's coming from our humanity and our traditions and your language and other things. And so this is a really important concept to grasp, is that all these things do is memorialize and codify these inherent rights that you always had, and that the UN agrees that you have these inherent rights. The three interrelated rights or inherent rights in the Declaration is the inherent right of self-determination, the right of the knowledge systems, heritage, and language of the Micmacs, the right to Micmac lands, territory, and resources, and the free and prior informed consent of Micmacs in all projects. Now, the key thing that Undrip does is talks about two things. One very much in detail, and it clarifies Aboriginal rights as inherent human rights. That almost all the provisions, except for one in the Declaration, are about your inherent rights. The other thing it affirms that we insisted on in the drafting of the thing is the supremacy of treaty rights. That those agreements that in Micmac Nation have made with other people are supreme over all other rights, because they make a decision, and their decision and a choice of our ancestors, and they come forward. And so what it says in translation is that the Micmac Nation has the right to the recognition, observance, and enforcement of the treaties concluded with France and Great Britain and their successors, and to have Canada honor and respect such treaties and agreements and constructive arrangements. But most importantly, it says that nothing in the declaration may be interpreted as diminishing or eliminating the treaty rights of the Micmac Nation, that they're still there. But what Undrip does is clarify existing Aboriginal rights of the Micmac Nation. It recognizes and reaffirms that Micmacs are entitled without discrimination to all human rights recognized in international law. And that's a very vast statement. There's more than 70 treaties on this issue in international law. And the Micmac Nation possesses collective rights which are indispensable for their existence, well-being, and integral to the development of a people. Article 45 affirms and clarifies to everyone in the UN and into Canada that nothing in the declaration can be construed or diminished or extinguishing the rights of the Micmac Nation now have or may acquire in the future. So this goes on into the future. That the provisions of Undrip also includes a balanced interpretation, and we need some kind of translation of these concepts of justice, democracy, respect for human rights, equality, non-discrimination, good governance, and good faith, because those are the principles of how you interpret the Constitution, interpret the Declaration. And they're important and they are essential. So in total, the Undrip affirms the Santa-Emanuel's communication to the UN's Human Rights Committee. It affirms that Micmacs have the right to maintain and strengthen their distinct political, legal, economic, social, and cultural institutions while retaining the right to participate fully, if they so choose, in the political, economic, social, and cultural life of Canada. That Micmacs have the right to maintain and develop their political, economic, social systems or institutions to be secure in the enjoyment of their own means of subsistence and development, and to engage freely in all their traditional and other economic activities. It affirms that Micmacs have the right to participate in decision-making in matters which would affect their rights through representatives chosen by themselves in accordance with their own procedures, as well as to maintain and develop their own Indigenous decision-making institutions. It also says that Canada shall consult and cooperate in good faith with the Micmac concerning, through their own representative institutions, in order to obtain the free, prior, and informed consent before adopting or implementing legislative or administrative measures that may affect them. So that's what we essentially communicated to the Human Rights Committee we wanted, that's now enshrined in the Declaration. But it's important to understand that the Micmacs have the right to all human rights and fundamental freedoms. That's in Article 1. And of course, Article 2 is with the right to be free from any kind of discrimination in the exercise of their rights based on their Innu origins or Micmac identity. Now, that first article includes the international human rights treaties that are legally binding on Canada under Article 1, applies to the Micmac Nation. And these are important conventions of eliminating all forms of racial discrimination, of the covenants on civil and political rights, on the covenants of economic, social, and cultural rights, on the Convention of the Elimination of All Forms of Discrimination against Women, the Convention of Torture and other cruel, inhuman, and degrading treatment or punishments, and the Convention of the Rights of the Child, and the Convention on the Rights of Persons with Disabilities, and the Conventions on the Protection of All Persons from Enforced Disappearance, all of these treaties have been affirmed by Canada. They haven't been implemented, but they're all implemented by Section 1 of the Declaration. And so it gives us a vast more rights than you think you have when you have to read all these things together. And of course, the Micmac Nation has a right to self-determination to determine their political status. And this gives them the right of autonomy or self-government in matters relating to their internal and local affairs. And it also provides the ways and means of financing their autonomous functions. But more importantly, and underscored in most of the discussions, is the Micmacs have the right to full labor and employment rights by the Declaration. Article 17 says basically that Micmacs have the right to enjoy fully all rights established by applicable international and domestic labor laws, and that Micmacs have the right not to be subject to any discriminatory condition on labor or any other object in employment and salary. Now, this not only brings in all the International Labor Organization covenants that are compatible and mutually enforceable with Undrip, but it also creates corporate responsibilities of all entities. And in general, we're looking, but we haven't explored it to the extent that we should, is that these rights may apply to continuing disputes with fishermen unions and other unions. Because of the ILO conventions, the fishermen's unions, when they fight us on fishing, may be in violation of international law. And we haven't worked that out, but we're looking at it as a research project. But most importantly, the Micmacs have a right to maintain traditional structures of self-governments. They have the right to promote, develop, and maintain their institutional structures based on their distinctive customs, spirituality, traditions, procedures, practices, and the judicial systems or customs as they exist. And Micmacs have the right to determine their own identity or membership in accordance with their customary and traditions. That the Micmacs, that Canada has to consult with the representative institutions of the Micmac Nation, which includes the Grand Council and district chiefs and other organizations, to acquire this free, prior, and informed consent. And this implies the nation-to-nation relationship that Canada is trying to pursue. But more importantly, the efforts that Marie Baptiste created in the principles and guidelines for the protection of Indigenous heritage are incorporated into the Declaration. And it says that Micmacs have the right to maintain, control, protect, and develop heritage and knowledge. And one of the important parts of that is a right to sciences, a right to designs, visual and performance art, but also the right to control, protect, and develop sports, and especially traditional games like hockey. This would imply that we have a right to create Micmac Nation hockey tournaments and hockey representatives in international events. But we haven't worked that through completely, but it's one of the things we'll start working on and thinking about. The Declaration is also important because it maintains the cross-border relationships. That since the Micmacs are divided by the border between Canada and the United States, the Declaration affirms that they have a right to maintain and develop contacts, relationship, and corporations with those Micmacs who are in the United States. This includes spiritual, cultural, political, economic, and social purposes. And so it provides a framework where Canada and the United States, in consultation with the Micmac Nation, can take effective measures to facilitate the exercise and ensure the implementation of these declaration rights on both sides of the border. And this has always been important for us because of the Micmac Nation and workers that go to Maine, and also important for Micmac migrant workers who go to Maine. And the Canadian government will now have to adjust this with our help.
They can't hear me.
So the Maui-Omi preserves our inherent and treaty rights through the declaration. And we've started the slow process of talking to the provinces in Atlantic Canada about making their laws that affect Micmac rights consistent with Undrip. And that's the next effort of the Grand Council, is to convince Nova Scotia, New Brunswick, Quebec, PEI, that they should pass complementary legislation to the federal legislation. But that's what we need to do forward, and people are just starting to work on that. And so the declaration under the Federal Act is going to create a new path forward toward reconciliation for Micmacs. And in the afternoon, you'll be looking at certain clauses and figuring it out. But we need to get a broad consensus of how all Micmacs on reserve and elsewhere, how do they want to work on the declaration through the federal government to achieve a better future. And the reconciliation journey has many steps that we're going to have to work through with the federal government. And we need a lot of participation and a lot of thought in this. And we have to take each of these steps one step at a time, just like we took the declaration, with perseverance and a lot of commitment to a very long story and a long future that we're trying to bring into existence. We've already done that. It's an epic story about how poorless people, through persuasion and through discussions, can create a better future and a better framework for a future for the people. That no one has ever been as poverty-ridden as Indigenous peoples that have gone to the UN and achieved so much from them, when before they weren't even recognized as existing. Now Canada has affirmed the declaration and is just starting the process. And we need everyone to turn their attention to how to do this, as well as all the other things. I'll conclude right there. Thank you.